Hi, my name is Adrienne Singh-Sreechan, and today we are looking at the terms and conditions on the website Priceline.com. This is an educational assignment and does not constitute as legal advice. I am not a lawyer, and if you have questions regarding the terms and use on your website, please reach out and seek legal advice from a lawyer. Now that we've got that out of the way, let's get into thoughts regarding Priceline.com's terms and conditions. Priceline is an online booking agency founded in 1997, known for name your price when booking flights and hotels. Priceline is now a part of Booking Holdings and is now one of the world's largest travel companies. You may be wondering, or you may not know, but terms of use is an agreement that a user must agree to and abide by in order to use a website or service. Terms of use can go by many other names, including terms of service and terms and conditions. Terms of use are often seen on e-commerce websites and social media websites, but it is not limited to those types of websites and should be used with any website that stores personal information of any kind. A terms of use that is legitimate is a legally binding agreement, and it is also subject to change, which should be noted in the disclaimer. Websites should always have a terms of use regarding user activity, accounts, products, and technology. After analyzing Priceline.com's terms and conditions, the question comes up if this is a contract. Let's talk about what is a contract. An agreement between two parties that creates mutual legal obligations. A contract can be either oral or written. However, oral contracts are more challenging to enforce and should be avoided if possible. Some contracts must be written in order to be valid, such as contracts that involve significant amount of money. Contracts are part of everyday dealings in all aspects of life. Therefore, it is crucial to understand the rules governing them to ensure you have a valid contract. All valid contracts must include the following elements to be enforced: an offer, an acceptance of an offer presented with something, a promise to perform, a valuable consideration, a time or an event of when the performance must be made, terms and conditions for performance, and also performance. On top of that, the courts will not enforce certain contracts unless they are in writing. These contracts fall under the statute of frauds and must be in writing. They include marriage contracts, contracts not to be performed within 1 year, interest in land contracts, paying descendants debt guarantors, and sale of goods contracts over a certain amount of time. Most contracts are governed by the state statutes, and therefore it is important to consider the local laws when dealing with a contract issue. Now that we got that out of the way, after analyzing the terms and conditions of Priceline.com, the terms of use is a contract, but it is not an enforceable contract. And in some court cases, as there isn't a way to determine the user knew about the contract. These are called browser wrap agreements, which is one that has the term of the agreement on the website itself and are connected to the main page of the product by a hyperlink. The hyperlink leads to another web page that will have the terms and conditions of the agreement detailed. With this type of setup, the terms do not pop up and do not require an action be taken by the user in order to continue. That means the user is not actively agreeing to the terms linked to the page. So on Priceline.com, the terms and conditions are linked at the bottom of the page via a hyperlink and is not visible unless you are looking for it. As I mentioned previously, in some court cases, the court deemed the browse wrap agreement not to be enforceable. You can see an example of this in a Zapdos class action lawsuit. So in January, Zapdos affected 24 million consumers. As typically happens in these situations, plaintiffs, class action lawyers swarmed over Zappos for the breach, filing dozens of lawsuits. Zappos tried to send the lawyers to arbitration based on the arbitration clause in its user agreement. However, the court stated, we cannot conclude that plaintiffs ever viewed, let alone manifested, assent to the terms of use. The terms of use is inconspicuous, buried in the middle to the bottom of every Zappos.com webpage, among many other links. And the website never directs the user to the terms of use. No reasonable user would have reason to click the terms of use, even those users who have alleged that they clicked and relied on statements found in adjacent links, such as sites' privacy policy. It also continues, the arbitration provision found in the Zappos.com terms of use purportedly binds all users of the website by virtue of their browsing. However, the advent of the internet has not changed the basic requirements of a contract, and there is no agreement where there is no acceptance. The meeting of the minds and no manifestation of assent. A party cannot assent to terms of which it has no knowledge or constructive notice, and a highly inconspicuous hyperlink buried among a sea of links does not provide such a notice. Because plaintiffs did not assent to the terms, no contract exists, and they cannot be compelled to arbitrate. So, terms of use is a contract, but it's not an enforceable contract. So that's something to look into regarding the terms and use on your website as far as Priceline.com. So the question comes up, can Priceline be sued by a user? Yes, they can if they do not follow the law or if they go against their terms and conditions, you have a right to sue. Actually, on their website, they mention this, but of course they state that they would like a chance to resolve any issues that their customer may endure. And I'm going to read a quote from their terms of use, terms and conditions on their website. You agree to give us an opportunity to resolve any problem, dispute, or claim relating in any way to the site and or any of its related applications or services. Any dealings with Priceline, including with our marketing or customer service agents, the purchase, use, or performance of any services or products available through this site, any representations made by Priceline or our privacy policy collectively claims by providing notice to customer support. Unless prohibited by applicable law, any claim must be brought within 2 years from the date on which such claim arose or accrued. We are unable to resolve your claim. If we are unable to resolve your claim within 60 days, you may seek relief through arbitration or small claims court. So they do have this on their website to let you know the proper steps that they would like you to follow before filing a suit against them. Now, Priceline.com has had several lawsuits that have transpired regarding their service or terms of use. Here's an example of one that I'll read as an example. On September 30th, 2017, Judge Robert N. Chackney of the United States District Court for the District of Connecticut denied Priceline's motion to dismiss plaintiff's claim, allowing plaintiff's claim to move forward against Priceline.com. The class action lawsuit alleges that Priceline breaches its best price guarantee promise when advertising tickets for Spirit Airlines because Priceline adds its own markup to Spirit tickets, unbeknownst to the consumer. In his ruling denying Priceline's motion to dismiss in its entirety, Judge Chackney held that plaintiff had adequately stated a statement for relief because it is plausible that a reasonable consumer would interpret the contract language to include a promise not to add hidden surcharges. So there you have it. Priceline.com can be sued. Lastly, I found that Priceline.com has a click wrap agreement, which is designated to ensure that the user has a chance to see the terms of use, and they must also actively agree to the terms in order to agree With this type of agreement, the terms are actively placed in front of the user so that they have to review and agree to them, which means that your website is better protected as a result. This also means that since the terms must be agreed to prior to any action taken by the user, they can hold up better legally if they are ever needed. Priceline.com has this in place when you book or purchase any of their services. But to better protect them, they should have one as a first stop before a consumer can utilize their website. Well, thank you for joining today. I hope this presentation was informative. Feel free to reach out if you have any questions. Please remember, as a disclaimer, that I am not an attorney. This presentation is for school use. So if you have any information regarding the terms of use on your website, please seek legal counsel by speaking with a lawyer regarding your website. Thank you for your time.